In the hallowed halls of Washington, D.C.'s federal courthouse, where the weight of judicial authority hangs heavy in the air, a remarkable confrontation unfolded that would etch itself into the annals of legal history, pitting Congresswoman Jasmine Crockett, a 43-year-old freshman representative from Texas with a formidable background in civil rights law, against Judge Beryl Howell, a 67-year-old titan of the federal bench whose reputation for exacting standards and sharp-tongued rebukes preceded her. This clash, sparked by Crockett's measured yet pointed comments to reporters about a controversial First Amendment ruling, culminated in a dramatic moment when Howell, her silver-gray hair impeccably styled and her black robe a symbol of unyielding authority, threatened to hold the Congresswoman in contempt, giving her a mere 3 minutes to justify why she should not be taken into custody by the marshals. A pronouncement that froze the packed courtroom, reporters scribbling furiously, law students leaning forward in their seats, and court security officers standing at attention as sunlight streamed through tall windows, casting dramatic shadows across the marble floor of the grand, wood-paneled chamber. Congresswoman Crockett, dressed in a tailored navy suit adorned with a single strand of pearls, rose from the second row of the gallery with a composure that belied the gravity of the moment, her legal acumen honed through years of challenging judicial overreach and her deep understanding of constitutional law, evidenced by her authorship of a respected law review article titled Constitutional Guardrails: The Proper and Improper Use of Judicial Contempt Powers, guiding her as she approached the podium to face one of the most feared federal judges in Washington. The tension was palpable, the silence in courtroom 22 broken only by the rapid tapping of the court reporter's stenotype machine, as Howell, a former federal prosecutor and Senate Judiciary Committee counsel appointed to the U.S. District Court for the District of Columbia in 2010, fixed her stern gaze on Crockett, accusing her of undermining the court's integrity with remarks that questioned the selective application of First Amendment standards in the high-profile United States v. Marson case, a matter involving political speech with significant implications for legislation Crockett was crafting in Congress. Crockett's comments, delivered the previous day outside the courthouse, had been carefully worded. While I respect the court's authority, today's ruling appears to disregard established precedent on protected political speech. The selective application of First Amendment standards raises serious questions about the decision-making process in these proceedings, yet they had clearly struck a nerve with Howell, who, known for her protective stance over the court's dignity and her history of sanctioning attorneys for public statements, saw them as a direct challenge to her authority, particularly from a sitting member of Congress with significant legal credentials. As Howell's voice hardened, warning of possible detention unless a formal apology was issued, the courtroom braced for what seemed an inevitable clash between unchecked judicial power and a congresswoman's constitutional prerogative. But what transpired in the next 90 seconds would not only defuse the threat but reshape the entire dynamic of the proceedings, leaving prosecutors, defense attorneys, and even Howell herself reeling from the brilliance of Crockett's response. With a nod of acknowledgement, Crockett opened her leather portfolio, her demeanor calm and professional, and began, "Thank you, Your Honor. Before addressing the specific allegations, I'd like to clarify my capacity here today and the legal standards that govern this situation," immediately establishing that she was not merely a politician but a licensed attorney with expertise in the precise constitutional questions at hand, appearing not as counsel but as a congressional observer with oversight responsibilities over the judicial system. A dual role that lent her comments a unique legal and constitutional weight. Howell, leaning forward with a hint of impatience, reminded Crockett of her familiarity with her identity, but the Congresswoman pressed on, undeterred, requesting permission to present a memorandum she had prepared addressing the legal standards for contempt in this context, a document that, upon Howell's hesitant approval, was handed to the bench, marking the first of several exhibits that would systematically dismantle the contempt threat. Citing Bridges v. California, Crockett argued that contempt sanctions are constitutional only when public comments pose a clear and present danger to the administration of justice, a high threshold her remarks, careful legal observations rather than personal attacks, did not meet, and as Howell reviewed the document, her stern expression betrayed a flicker of caution, sensing the depth of Crockett's preparation. Undaunted, Crockett presented a second exhibit, the full transcript of her press comments, emphasizing that she had explicitly prefaced her critique with respect for the court's authority, framing her statement as a substantive legal observation about inconsistent First Amendment applications rather than an assault on judicial integrity. a distinction that began to shift the courtroom's atmosphere as legal observers exchanged glances, recognizing the sophistication of her defense. Howell, still skeptical, countered that public statements questioning a court's impartiality could influence public opinion and interfere with proceedings, but Crockett was ready, producing a third exhibit citing Landmark Communications versus Virginia, which protects commentary on judicial proceedings by public officials with oversight roles, and Standing Committee versus Yagman, Ninth Circle 1995, which holds that attorney criticism of a judge is protected unless it involves objectively and subjectively false factual assertions, criteria her comments clearly did not meet, as they were grounded in legal analysis rather than falsehoods. The courtroom remained hushed as Crockett, her voice steady yet infused with quiet authority, presented a fourth exhibit detailing her legal credentials, including her successful litigation before the Texas Commission on Judicial Conduct and her law review article, underscoring her expertise in contempt law, a revelation that prompted frantic note-taking among journalists and a visible recalibration in Howell's demeanor, her initial confidence giving way to cautious reconsideration. In a final, masterful stroke, Crockett introduced a fifth exhibit, a transcript from Howell's own 2019 ruling in United States versus Rodriguez, where the judge herself had stated, "Thoughtful criticism of judicial decisions, even strong criticism, serves an important function in our legal system and rarely rises to the level of contempt, absent direct interference with court operations." A direct quote that stunned the gallery and drew a sharp glance from a court security officer to quell the ensuing murmurs. Crockett concluded, "Unless the court finds that my comments posed a clear and present danger to these proceedings, a standard that requires specific evidence of harm rather than general concerns about propriety, the Constitution and this court's own precedent do not support a finding of contempt," closing her portfolio with a gesture of finality that left the courtroom in profound silence. The balance of power subtly but unmistakably altered. Howell, visibly taken aback, announced a 15-minute recess to review the materials, which stretched to 30 minutes as she retreated to her chambers, leaving the courtroom buzzing with whispered speculation about the unprecedented exchange. Upon her return, Howell's demeanor had shifted markedly, her earlier sternness replaced by a collegial tone as she addressed Crockett, acknowledging the nuance of her comments, the strength of her legal arguments, and her substantial expertise, before withdrawing the contempt warning entirely, stating, "Your comments, while critical, did not cross the constitutional threshold for sanctions as established by the Supreme Court." The gallery exhaled collectively, but Howell went further, surprising everyone by inviting Crockett to submit an amicus brief on the First Amendment issues in the Marson case, a request both the defense and prosecution accepted, though the latter with visible hesitation, caught off guard by the turn of events. Crockett agreed to provide the brief, her brief smile reflecting appreciation for Howell's willingness to reconsider rather than any sense of personal triumph, and as the judge moved to the day's scheduled matters, she made a historic statement, noting, "The contempt power is perhaps the most significant authority granted to a judge. Precisely why it must be exercised with the utmost restraint and strict adherence to constitutional boundaries," thanking Crockett for her professionalism and expertise in a rare display of judicial humility that left legal observers stunned. 3 weeks later, Crockett's 40-page amicus brief, described as a model of constitutional analysis, prompted Howell to reverse her earlier evidentiary ruling in the Marson case, admitting that she had not fully considered Supreme Court precedents on political speech, a decision that quoted Crockett directly and reshaped the case's trajectory, potentially altering its outcome. The exchange's ripple effects were profound. Video clips went viral in legal circles. Law schools incorporated the proceedings into curricula on constitutional law and professional responsibility, and the Federal Judicial Center announced new training for judges on contempt powers, citing the Howell-Crockett confrontation as a catalyst. Legal commentators, including Harvard's Professor Miranda Chen, praised Crockett's procedural mastery and respectful tone, noting, "She didn't grandstand or make it personal. She systematically dismantled the legal basis for the contempt threat while maintaining absolute respect for the court as an institution," a sentiment echoed across social media, where users lauded her composure and legal brilliance with hashtags like #LegalMasterclass and #RespectfulAdvocacy. The Constitutional Accountability Center hailed the exchange as a model for how principled critique strengthens the legal system, while the Judicial Conference of the United States formed a committee to review contempt guidelines, influenced by Crockett's arguments. Months later, at a Columbia Law School conference on judicial ethics, Howell and Crockett appeared together, their collaborative dialogue showcasing how initial conflict could evolve into constructive engagement when grounded in mutual respect and constitutional fidelity, with Howell reflecting, "The goal of our legal system isn't winning arguments or asserting authority. It's arriving at just outcomes through faithful application of constitutional principles," and Crockett adding, "Effective advocacy doesn't require theatrics or personal attacks. When you're grounded in solid legal authority and present it with clarity and respect, you create space for genuine reconsideration." The exchange became a touchstone for judicial accountability, inspiring judges to invite substantive critique rather than pursue contempt sanctions, and Crockett's parting words to a law student, "When you know the law is on your side, you don't need to raise your voice. The Constitution speaks loudly enough on its own," became a mantra in law school classrooms, encapsulating the power of preparation, expertise, and principled advocacy to transform even the most daunting legal confrontations into moments of constitutional triumph, a legacy that continues to shape discussions on justice, accountability, and the delicate balance of power within America's legal system.